Mr. Spiller, you can come on back up to the witness stand. Anything from either of the parties before we start with testimony from the state?
No, thank you.
From the defense?
No.
All right, then go ahead, have the jury brought out. Oh yeah, I'll give that to you. Just making sure those are all over there. The bottles. We have two.
Yeah, this one was, we haven't offered this yet, but it's over here.
Oh, that's right.
If anyone needs any.
Thank you, everyone. Please be seated. Mr. Spiller, do you acknowledge that you remain under oath?
Yes, Your Honor.
Thank you. All right, Attorney Nicolai, when you're ready then.
Thank you, Judge. Good afternoon, Mr. Spiller.
Good afternoon.
As we begin kind of talking about the things that you testified to this morning, I think it might be helpful for the jury to kind of get a picture in their head of, I think it's fair to say there's three kind of big groups of toxicologists involved in working on different things, whether it be clinical or forensic. So I want, you indicated that at the Poison Control Center, when you're assisting people at a hospital remotely, it would be fair to say that that's a group of people who have called to say, I need help, something has happened, and the Poison Control Center is involved, and the person ultimately survives. That's kind of one set of
Mostly everybody survives.
Okay.
Mostly everybody.
Sure. And that would, when you're doing toxicological work with people who are in a hospital and they're released, that's kind of called clinical toxicology, right?
Yes.
Now, there's kind of a second set group of people that you certainly have experience with, and that's people who, again, call for help and, you know, seek treatment, but they don't survive, right? And they end up dying. Is that true?
Yes.
And you've been involved in a review of those kinds of deaths when the Poison Control Center is involved. Is that fair?
Yes, we have to. As the director, I have to sign off on it. So yeah, it's about 40 a year.
Okay. And I just want to be clear, because you're not signing off on a death certificate in those cases, right?
No, this is third part of the review for what we call National Poison Data System. We go through 3 levels of review for fatalities to make sure that it's a fatality. The first level of review is at the center level, where you gather the hospital records, the coroner's report, postmortem if you have it. They don't always have it, as much as you can, and you put it together and you say, this is what happened. You know, on day 1 we saw them, you know, and you progress through. They may have lived for 3 days, but eventually they succumb. Then there's a second level of review called the Fatality Review Committee. And those, it's like peer review for the fatalities. And I'm also involved in that as well, but I don't review my own. And so you review those and you get back to the original center because there's something missing, do you want to say? And you ultimately, at that second level, you make a determination whether it's undoubtedly related. And to be undoubtedly related, you have blood levels. Pretty much Probably related. You have a clinical picture that is unquestionably a clinical picture of this overdose. This is what happens, and then they succumbed. Then there's contributory. Contributory is there may be people with significant other medical issues that this particular toxin, whatever it was, knocked them over the edge. It might not have knocked an Olympic athlete over the edge, but these people, because of their significant medical issues, that wouldn't have been in the hospital and cascaded down to ultimately death. That's contributory. And then there is not related. So you find related, probably related, or absolutely related, probably related, contributory, or not related. And that's the second level. And then the chairs of these committees, this goes on for about 6 or 8 months. All of these are reviewed nationwide. They go over it again so that the data gets in there. We're most concerned about the fatalities because that's what everybody wants to know. So we do a 3-level review of all fatalities and everyone gets to see if we're not certain if it's related, if it's probably related. Quacks like a duck, it floats on water, it's got orange feet, et cetera, et cetera. You're like, probably related. If we got DNA and it's like, it's a duck, we're like, okay, that's definitely related. And so we go through these levels and they're spelled out.
You'd agree with me that you are not a medical examiner.
Correct.
And you're not a coroner.
Correct.
And you'd agree that those are different things.
Yes.
And you are not making signatures on death certificates yourself, ever.
No.
Okay. So you'd agree with me that the review that's being done for the data that the Poison Control Center keeps and maintains is different than the process that a medical examiner would go through in making her cause of death determination for the death certificate. Fair?
Yes, there are a couple of differences, but
Okay,
yes.
2 different things.
Oh, yes.
Okay. So now everything that you talked about it in the second group that you just discussed in detail, the review process of fatalities, all of those cases eventually in some way involved a poison control center. True?
If they're in MPDS, yes.
Okay.
Yes.
So there's kind of a third group of people who have, let's say, ingested something, succumbed to it, and the Poison Control Center was never contacted, police were never contacted, and the person is found deceased.
Yes.
And then you would have no involvement in something like that.
Sometimes the coroner calls us and says, what is this? Like, for instance, there was a selenium death, and the coroner had no idea of what was going on with selenium. I happen to have published papers on selenium, so they contact me. But that is not that's not MPDS. That's independent, and that's one of the coroners in the state I'm in.
And let's talk about the difference between a coroner and a medical examiner. How would you describe that difference to the jury?
Coroner is an elected official, and it depends on the county and the state what determines the coroner, but you are elected. A medical examiner is a pathologist, an MD or DO pathologist, who can do autopsies and those things. So, like for instance, in Kentucky, there were a number of relatively poor counties where the medical examiner ran the funeral home.
Okay, so a medical examiner is a medical doctor. True?
Yes. Yes.
A coroner doesn't necessarily have to be a doctor of anything. True?
Depending on the law of that county.
So true?
Yeah, true.
Okay.
Whatever the law of the county says.
So you said there was one time that a coroner somewhere called you about selenium, right?
Well, I was just using that as an example, but yes, they do.
Okay. So this third group of people who are found deceased, fair to say that that process kind of involves a whole group of other people like law enforcement, medical examiners' offices, and forensic toxicology labs that the Poison Control Center is not involved with.
Most of them not.
Okay.
I mean, if they're found dead and stay dead, unless they have a particular question about a substance, when, for example, when the OxyContin issue showed up, hillbilly heroin, I get a lot of calls from the coroners out in Eastern Kentucky.
The coroners, not the pathologists.
Correct.
Okay. So you're aware that in this third group of people who are found deceased and the investigation involves law enforcement up to a medical examiner and a forensic toxicologist, that it would be very infrequent for that process to require someone like you to make reverse dosing calculations. True?
It would be infrequent. Yes.
The
I mean,
process
it's
that I've
usually not.
outlined-
They go to these tables that most people go to and they just look at a number and they go, boom, here it is.
So the process that I've outlined, where a medical examiner is forming an opinion about the cause of death, routinely is happening in this country every day
Mhm.
without any toxicologist doing reverse calculations from a level in the toxicology to a dose of pills. True?
For the most part, yes. I mean, I've
Okay.
testified in cases where it was part of the case and we did a reverse calculation in a 2 and 4-year-old. So they do contact us when there's issues that they want us to help with, but it is infrequent.
This process of the signing of death certificates all over the nation that is happening every day, the vast majority of those determinations are being made without the knowledge of a reverse dosing calculation. Would you agree with that? Yes or no?
Yeah, I'll probably agree. Sure.
Okay. So
They
then
just go
why
to the
is
tables.
that
I'm
was my
sorry.
question. Thanks.
Sure.
So then why is it important for this jury?
To be able to complete his sentence.
The question called for a yes or no answer. This is cross-examination, so overruled.
Now, you've indicated before that the reason that it's so helpful to do these types of calculations is because these medical examiners don't know what the levels mean, right? You've said that before.
Well, they refer to tables that people have published that says, we found 4 fatalities and this is the range. And they look at theirs and they go, if that's in that range, they're like, okay, I got it. They're not doing studies on these levels. They're just referring to the tables. And if it's in that range, they got it.
But you'd agree with me that if a substance hasn't been absorbed into someone's blood.
Hi, Mark Barden. It's Sandy Hook Promise here. When the gunman shot his way into Sandy Hook Elementary School on December 14th,
That it's imperative for them to know how many tablets were ingested in this case. True?
Well, I think it's helpful to understand that this is not 2 tablets or 4 tablets. This is 30 to 40 tablets.
And you said handfuls, right? Handfuls of tablets is what you testified about, right?
I have recently, I'm 69, I've recently had to begin taking medications. And yes, I cannot swallow more than like 3 or 4 at once. I can't swallow 30. I'm taking my experience of trying to swallow tablets and I'll put them out and I'll just, have to do it that way.
And if we could please publish States 35.
Go ahead.
Page 1. Which exhibit are you bringing up? 35. Thank you. You'd agree with me, sir, that the iliac blood levels in this case
Yes.
are the levels of substances that were affecting the decedent at death.
Yes, that they found. Yes, definitely. Only what's in the blood.
And you know from looking at Exhibit 35 that NMS Labs has included various notes for the reader in terms of those charts, I think that you call them, charts of levels, right?
Okay.
And you were asked about some of those before. If we can scroll down to page 4, they're called reference comments, and you were asked to read real specific sentences from some of them.
Mhm.
For example, this morning, looking at number 5, you were asked to read the important part of that information this morning. And to the jury, what you picked out of that to read was the last sentence. In combination with other central nervous system depressants such as ethyl alcohol, alprazolam can become toxic at low concentrations. Do you remember reading that?
Yes.
The sentence right before that, sir, says reported blood concentrations of alprazolam and alprazolam-related fatalities ranged from 100 to 400. True?
Yes.
Okay, so you're aware that these reference comments that are put on this, or any reference comment that a medical examiner might use to interpret toxicology results, are born out of these cause of death determinations being made over and over and over again, right?
Yes, I have an answer for that, but you're not asking it, so I only answer your questions.
Thank you, sir. So Dr. Kurczewski and every other medical examiner's office in the country is continually making cause of death determinations and signing death certificates, right? And anything involving an overdose will also involve these toxicology numbers like on page 1. True?
Object to a
Usually.
compound question, object to a compound
Sustained
question.
is to the form of the question.
And to the MEs across the country.
It's
Yeah.
sustained.
Thank you.
If we can go back to page 1. Sir, you'd agree with me that one way that these ranges are determined is by collecting all of this data that exists during the process of making a cause of death determination.
This data isn't collected. What gets collected is published literature. They're pulling those numbers out of the published literature. They're not collecting these reports. And so there needs to be a difference between what's here and what's there. So they've done, I mean, I've done this, but the coroner, we would have a monthly coroner meeting in a medical examiner meeting in Columbus, and we would go over the cases. And we would disagree and explain to them why. They'd find cocaine on someone and said, you know, it's a cocaine death. And we'd look at the level and say, no, it's not. And we'd explain to him this: when he called 911, he had a history of asthma. He was admitted to the hospital only 3 days before for asthma. He was calling with shortness of breath, which is asthma, and he goes in and he dies. And they're like, so they didn't know what it was. He just shows up. They do toxicology. They find cocaine. They said it's cocaine. And we're like, no, look at these levels. And so just finding a level does not mean an effect. And that's just one example. That's why they would bring us into these medical examiner monthly meetings for Columbus, whether it be, they'd also bring in police, jail, a number of other people to give their opinions on a number of things, you know.
Okay. That wasn't my question, so I'm going to kind of break it up to make it a little bit more simple. You'd agree with me that levels like this contained in forensic toxicology reports are from someone who is dead.
Yes.
And you'd agree with me that medical examiners frequently use this kind of data as a piece of their decision about cause of death.
Yes.
And you'd agree with me that when those determinations are made over and over again, researchers like yourself can use this data to publish literature about it, right?
You can't get this data. This is private data. You can't get these lists. This has to do with her. Like, I can't just go to them and say, give me all your fatalities for the last year and I want to do this sort of thing. You know,
Sure.
So,
Let's go down to page 5 again, please.
so
Finish it.
there,
You're on.
there is a difference between doing research on the postmortem levels, excuse me, and that report. So no, access to that is not widely available to anybody who just wants to look at it.
So at some point in time, someone was able to get data about baclofen deaths, and they formed that data together into a study. And the last sentence of number 9 on the page being displayed says, in a fatality attributed to baclofen, postmortem blood and urine concentrations of 17 and 760 respectively were reported. Is that what that says, sir?
Yes, it does.
So someone got that data and put it together, and it's been put in a form that's useful to a medical examiner. Fair?
Sure.
Okay.
The sentence before is, I think, more
There's
important.
no question.
I'm sorry, I apologize.
Thanks. Nothing about this process that we've just discussed has anything to do, going back to page 1, with trying to calculate backwards what these numbers mean in terms of how many pills someone took. True or false?
True. No, I don't think they do. Which goes back to that cocaine case. We did back calculate and showed them that it wasn't cocaine, it was asthma.
In this case, you've made a couple different set of these kinds of calculations to this point, right?
I don't understand the question. I have made some calculations, yes.
So one of the sets of calculations is something that got turned over to the state back in July of 2022, and it's in your report, 545. Fair? There's calculations in here.
Mhm.
Is that a yes?
Oh, I apologize. Yes, I'm sorry.
And you'd agree with me that when you add up the calculations that you made in your report in Exhibit 545, the total tablets are 21 to 28. You'd agree with me that that's the number from your report dated July 28th of 2022.
I'm sure I did, but I don't remember. I don't
Okay.
see it.
Today, in the table that you were shown, Exhibit 622, you've testified that the number of tablets is between 33 and 42, and that was a very conservative estimate. Do you remember that?
Yes,
Okay.
I added hydrocodone and ropinirole to that list. They're there. They weren't initially included in this written report.
You'd agree with me that by definition, when you offer opinions in court, like these calculations, that is a forensic toxicology opinion.
By definition, I think anything in court is forensic.
Okay.
I think that's the definition of it.
Are you aware, sir, that there is an academy, American Academy of Forensic Sciences Standards Board, and they publish for anyone offering such opinions,
Anyone that is
practices
a member
and
of their academy, not anyone offering such
Hold on,
opinions.
sir.
I
Mr.
have to
Spiller, Mr. Spiller, the question wasn't even fully asked, so I'm just gonna ask
Okay.
that you wait until it's fully asked before you answer it. It's a difficult job for the court reporter. Please don't talk over each other. Thank you.
Yes, Your Honor.
Can you please re-ask?
Thank you, Judge. Sir, you're aware that the American Academy of Forensic Sciences Standards Board publishes guidelines for opinions and testimony in forensic toxicology. Are you aware of that?
Yes.
I'd like to show this witness exhibit 232. If we get unpublished, please. And just the witness. Let me know when you can see that, Mr. Spiller.
Exhibit 232?
Right.
Yes, I can see it.
And on the right side, there's actually some page number. You can tell there's 10 pages to that PDF. Is that fair?
No. Oh, yes, I see it. Yes, I see what you're circling.
Is this, do I have a copy of this?
May not judge.
Thank you. I appreciate that.
I have a paper copy, Mr. Spiller, if you prefer to look at that, but you can tell there that it's a multi-page exhibit, right?
Yes,
And the title of it is what we just talked about, the Guidelines for Opinions and Testimony in Forensic Toxicology.
yes,
And you're aware of these.
yes. That's a statement by that academy. I'm not part of that academy.
And at this point, I'd move Exhibit 232 into evidence, ask for permission to publish.
I'm going to object. He's not part of the academy. He has not acknowledged this document as being authoritative or that he even knows anything in it.
The objection is sustained for now. If you could ask a few more questions, please.
Well, sir, are you aware that these best practices are recommended for anyone offering opinions and testimony about the topic of forensic toxicology, regardless of what board or association they may belong to?
I would disagree, and I'm not a member of that academy. They can't speak to other academies.
I'm asking you about a set of guidelines that are published for anyone in the forensic toxicology field for best practices. So there's a board that many toxicologists probably aren't members of, but they publish these guidelines.
Yes.
Because it's important that expert testimony be constrained to areas that are based on sufficient facts or data.
Object to the state testifying.
Judge, this is cross.
Oh, she's testifying.
Let me see the attorneys at sidebar, please.
Oh ho. Oh, well, he wasn't answering the question, so she should have called for him to. She should have called for let the record show the witness is non-responsive. Hmm. Ho ho. Maybe Jessy should try wearing something like that berry-colored jacket that the prosecutor has on. Seems to me she does well. She'd do well with a bit of a color to her wardrobe, but she seems to like those big chunky cowl knit collar sweater things. I think that Judge Dorow is ready for this trial to be over because she seems to be a little on a shorter
Mr. Spiller, I'm going to hand you
with
Martha's
the
Exhibit
defense.
232. That was the same thing that you were actually just looking at on your computer, but I want you to flip through those pages, okay? And sir, you and I have actually already talked about this document once, didn't we?
I think we had a Dahlberg hearing. Is that what you're referring to?
Right.
Okay, then yes. If that's what we're referring to, yes.
If you flip through those pages, does this look like the same document that was an exhibit at that hearing?
I don't remember. That was quite a while ago.
Have you ever seen exhibit 232 before?
It's not my society or academy. I don't keep it, no.
That's not what I asked you, sir.
Have I seen it before? Maybe. Yes, maybe. I'm sure. But I don't retain it to memory because there's a number of boards and I only keep track of the ones that I'm part of.
Sir, you're a member of the Society of Forensic Toxicology, are you not?
I haven't been in part of it for a while.
So you weren't at the meeting last week when this document was discussed in great detail?
That's
as
not
it-
the Society of Forensic Toxicology. This is a different society.
It's really important for you to wait for me to finish my question because the court reporter has to take down both of our verbal indications, okay? So my question is that this association that you were a member of, the Society of Forensic Toxicology, there was a meeting last week. Do you know that?
No, I haven't been part of that society for probably 10 years. I have to
This set of guidelines was discussed
Okay,
at that society that
okay.
you belong to.
Used to, yes.
At this point, I'm going to move in Exhibit 232.
Well, I object based upon what I've said before. He's not a member of the society, so I'm not certain. So I stand by my objection on that.
The objection is overruled. Exhibit 232 is received. Permission to publish is granted.
And I'll just wait till I get a thumbs up here from the jurors. It shows, there we go. All right. If we go to page 3 and blow that up a little bit, can you please read the first paragraph of this page into the record, sir?
At the top 5, 2. Oh, my
I'm
3
sorry,
has
what?
the appropriate opinions and testimony by a toxicologist. Am I looking at the wrong page 3? The paper copy you gave me.
Mine's different too than what I'm showing on the screen.
Is the paper copy double-sided, sir?
No,
Okay, so then, can you count the pages with your hands and turn to the third one in the exhibit that you have, sir?
yes,
Okay, does that
It
match
says
page
forward.
3?
yes, that's
Okay.
what it, yes.
Could you please read the first paragraph to the jury?
I can't hear you.
Could you please read the first paragraph aloud to the jury?
I'm sorry. Could you repeat that?
Sure.
I got a cold from the airplane and I'm having trouble.
Sure. Could you read that first paragraph on page 3 of States 232 to the jury, please, sir?
Yes. It is common that forensic toxicologists are called to testify in criminal and civil matters to discuss analytical results and offer their expert toxicologic opinion.
Continue.
In these legal matters, it is important that expert testimony be constrained to areas that are based upon sufficient facts or data, be a product of reliable principles and methods, and that those principles and methods are consistently applied to the facts in the case at hand.
Continue, please.
This document provides one way of ensuring the proper toxicologic testimony is allowed in legal manners by defining the general areas of forensic toxicology that are viewed as reliable by other experts in the field.
You would agree with me, sir, that nothing about what you just read indicates that there are limitations for the groups that these are best practices for.
I do not understand the question.
You'd agree with me that the paragraph that you just read does
Yes.
not have any kind of a limitation in terms of who these should apply to by board or society. Fair?
No, it's just that it says ASB best practices at
It
the top of
actually
the page.
says that they should apply to people testifying about forensic toxicology. True?
Yes, but they're talking to
Okay,
their
thank
members. They can talk to people that aren't their members. They're not members of that society.
If we can please go down. And again, and again, and again. And the bottom of this page, please. Sir, do you see the whole section that talks about inappropriate opinions and testimony by a toxicologist?
Yes.
Can you please read item G?
A toxicologist should not calculate the dose of a drug based on a postmortem drug concentration in the blood or in blood.
Thank you, that can come down. Sir, you'd agree with me that there are a lot of pitfalls in trying to calculate a dose from a postmortem level
Yes.
because there's so many unknowns, right?
Yes, there are. And I'd like to explain some of them. They're
I'd like to talk about those with you too, sir.
good.
Is one of them genetic factors and metabolization rates?
They could be, yes.
Is another one-
But yes.
Is another one of them time? Levels can be affected by time.
Well, time you're alive.
Is it your testimony, sir, that once a person dies, those levels cannot be affected post-mortem?
They don't change much. This is a big issue in postmortem toxicology. Is there postmortem redistribution? There's got to
Do
be
you
50.
believe that's a true thing or not?
In some, but not all, probably a minority, yes. But it is enough that the solution to that has been to get peripheral blood, which they got. They got iliac blood. The solution has been not to get heart blood, which is central blood. They just take it out of the chest. The solution for postmortem redistribution has been to go for peripheral blood, and they did. They got iliac blood.
You'd agree with me that postmortem redistribution can affect the accuracy of levels in toxicology? Yes or no?
Some, not all, no.
So yes.
So there is no yes or no, some.
You'd agree with me that disease and illness can impact a metabolic rate in someone?
Disease and illness, yes. Up to a point, yes.
And
Depends on the disease and the illness. Really, the effect is going to be hepatic injury because that's where drugs are metabolized. So if we have significant injury to the liver, definitely. If your disease is, I have an infection in my foot, no. So it's not just disease and illness. It's what specific disease and illness and what organ are we talking about?
and hepatic is an important one, right?
Yes.
This jury even heard from Dr. Thomas yesterday that hepatic injury or hepatic steatosis would be a really important thing for someone to know about if they were doing these calculations post-mortem.
You would take it into account, yeah.
Okay.
How
And-
severe?
And you're familiar with the fact that you testified about this case in December of last year, true?
Well, we had a hearing on, could I testify, a Daubert hearing.
Okay. You
Yes.
had already created your report in this case, true?
Yes.
Okay. And at that point in time, you did not have the medical records to read in this case, true or false?
I did have medical records. We can go back to the original opinion, but I had the medical records of, hold on, Waukesha County Medical, inventory of Medicare. There was the medical records. Oh, no, apparently they were supplied later. Yes. So they were supplied later. No, I did not, when I wrote that originally.
Okay, and when you completed these calculations, it was your belief that there was no evidence of hepatic injury in Lynn Hernan. True or false?
I tried to use what I call conservative numbers, the lowest numbers I could that took into account the
Sir,
number of issues. I
That's
did not have her medical
responsive
record at
to
the
my
time. No,
question.
I did have the autopsy, and the autopsy says that it was there. I did not have the hospital record, but if you look at the autopsy, it defines that. So I knew of it, but I did not have the actual lab values from the hospital that the medical examiner drew that conclusion.
This was my question in December of 2022 to you. If these types of circumstances impact post-mortem toxicology levels, how is that not important for you to look at it? Your answer, quote, I've explained this, period. There's no evidence of hepatic injury, period.
Okay.
Sir, are you aware that in fact there is evidence of hepatic injury in this case regarding Ms. Hernan?
Yes.
Thank you. Nonetheless, you've done these calculations that the jury has now seen, right? Using, you'd agree with me, several assumptions.
Yeah.
Okay.
That's kind of vague, but yes, there were several assumptions.
I want you to tell this jury and myself what the equation was that you used to go backwards from toxicology levels to pill amounts, please.
The clinical trials of each drug. Before you go to the FDA, you have to do 1, 2, 5 milligrams, whatever it is. You know, you give them 220, then you do another study, If you give it twice a day, 3 times a day, if you give it 3 times a day for 2 weeks, does it build up? A number of things. And you can go through that. It is human data, specifically on that drug. And you know how much they got because these are clinical trials. There's nurses giving these people these tablets at a specific time on a clinical trial unit. They're not home saying, I'm going to take it every 8 hours or something. They're in a clinical trial unit. And so you can look at these and say, okay, 5 milligrams 3 times a day or 20 milligrams once a day produces these levels. This is something the FDA accepted and I accepted. So that's to get to those levels. Those are referred to as therapeutic levels. And there are therapeutic levels depending on what dose you're taking and how often you're taking it. Because some drugs you take twice a day, 3 times a day, some you take once a day, etc.
Sir, you'd agree with me that clinical trials are done on people that are alive, true?
Yes.
And clinical trials report levels from samples taken from people who are alive. True?
Yes,
And those trials have the benefit of taking many samples over time. True?
yes,
And there's the benefit of recording the data in terms of the level and time as it correlates through the study.
yes. Peak levels, half-life, a number of things, how long it stays in the blood. They report the whole pharmacokinetic parameters.
You mentioned amitriptyline this morning. Do you remember that, sir?
Yes,
Are you aware of a 2021 publication in the Journal of Forensic Sciences that involved that substance?
you'd have to be more specific. I read a lot of papers.
Sure. The author is PhD Peter Manskell, and the title of it is Just Say No to Postmortem Drug Dose Calculations.
Okay,
Are you familiar with that paper?
no.
This was published.
Object to any further discussion about it. Wasn't submitted as a learned treatise, and he's not familiar with it.
Sustained for now. I'll take it up outside the presence of the jury later.
I want to ask you some questions about your article, Drug Facilitated Sexual Assaults.
Mhm.
And I believe that was entered into evidence this morning. And you testified to this jury that because of that publication, you were successful in getting tetrahydrozoline added to rape check panels.
Well, the FBI recommendation for what you check for, yes. I mean, you don't have to use the FBI recommendation, but that's what we wanted. It eventually got there because publication is a slow process. You write the paper, it gets published, other people read it. But yes, we were ultimately, it is now part of the FBI list of things recommended to check for.
To check for when?
When there is drug facilitated sexual assault.
Okay. So here in Wisconsin, we call that a sexual assault nurse exam, a SANE exam.
Okay,
And levels are pulled, samples are taken during those exams. Is that the rape check that you talked about earlier?
yes.
Do you know whether any hospital in Wisconsin includes tetrahydrozoline in those checks?
I'm not from Wisconsin, I don't know.
Okay. Even if they did, you'd agree with me that those samples taken during sexual assault nurse exams have to be sent out to labs to test for levels. True?
Yes, yes. You're not going to get it in an ER or a hospital. It's a pretty exotic test.
Okay.
It'll be sent out.
You testified a lot this morning that dizziness is something that someone that's ingested tetrahydrozoline may suffer from. Do you remember that?
Yeah, they do complain of dizziness. Complain about a number of other things.
Would you agree with me that the article that you wrote defines the use of tetrahydrozoline for chemical submission?
I'm sorry,
Of a victim?
I do not understand that question. What am I being asked?
Would you agree that individuals using tetrahydrozoline to facilitate a sexual assault use it because it makes the victim unable to resist the attacker?
Yes, I would say yes. They usually mix it with alcohol. They can mix it with other drugs, but they usually mix it with alcohol as well.
And you'd agree with me that It's also selected because it impairs memory, so the victim is less likely to accurately recall the circumstances.
Yes, if you talk to the victims, they have these periods where they wake up and they're like, ah, and then they fade out again. And there's often 2 or 3 of these episodes before they finally wake up and get out of there. But they don't wake up and stay awake. It definitely impairs memory. But they have periods where they wake up and they can give you these memories like they're in a bed naked or something. So it's these periods of like where they're alert and then they kind of get drowsy again.
And you'd agree with me that the drug is also selected because it impairs judgment, coupled with reduced inhibition, giving the attacker the impression of collaboration or submission by the victim.
I would say yes. When they mix it with alcohol, yeah, I would say yes.
And just so you're aware, I'm reading from your paper on
Okay,
this
I
verbatim.
agree with me.
Okay, good. You'd also agree that it's selected because it's a substance that's not routinely detected on standard drug analysis screens.
Definitely. That was one of our efforts, was to have it added to the FBI list. Whether they use that list, that's up to them.
Mhm.
But we wanted to get it on the list.
And the selection of that substance might also have to do with its availability to the perpetrator.
Yes. Mhm.
I next want to move to your exhibit number 623. If we could please publish that for the jury. If we could blow it up, please, Mr. Volcanier. Sir, you'd agree with me that there's missing information for the clinical effects at peak for the first 3 entries in this chart.
Well, that's when they got the blood level of 51.4, but they have a clinical history of what she's doing. The parents brought her in. So they have an understanding of what's going on, which is why they went and got the tetrahydrozoline level, so yes, there is a history of how the child was doing in the previous hours. They don't have blood from the previous hours, but they know what was going on with the child.
Can you please circle the number 115 on your exhibit that you prepared?
Just on here?
Sure, it'll make a little mark actually. Sir, that number is a calculation that you did, yes or no?
Yes.
Okay. That can be cleared, Madam Clerk. The second line of this exhibit that reports a level of 39.3, do you see where I'm at?
Yes.
You'd agree with me that although it's not listed, that toddler ended up in the ICU.
Yes. Not an uncommon thing for a toddler.
And going to the line below that, can you please circle the box where there's no information regarding intervention so the jury can see where we're at? You'd agree with me that in that Lowry study, this toddler had a Glasgow coma score of 10 and was unarousable.
If you're reading it, I'm going to say yes.
You'd agree with me that where your circle is, it might have been important to put down that that child was on a ventilator for 10 hours.
Yeah.
Okay. The next 2 lines are statistical trickery. True?
I have to say the use of the mean and the median, and to say that these are postmortem levels. We went through this, but the median shows you that 56 of these 112 are meaningless. They're there. You can find them. They have exceptional clinicians at NMS. They found it, but was it clinically significant at less than 1.7.
I'll ask it again. You told this jury this morning that those 2 rows are, quote, statistical trickery. True or false?
I still agree with that.
So true.
True.
Now, when you look at Exhibit 623, you'd agree with me that you didn't include every single piece of information that you could on this chart, right? Of every published article about this substance that's ever existed. This is a summary, right?
This is ones that had blood levels. Only ones that had blood levels.
You suggested this morning when you talked about this chart that these kiddos were fine and that you were next to them in the ICU in their bed watching them and all they needed was observation. Do you remember that?
Sustained is in the form of the question.
You testified this morning that those children involved in this Lowry study were absolutely fine. True?
Well, they might have been drowsy, but they needed no medical intervention. They were not intubated. They did not have pressors going on. We didn't have to put a liter of fluid into them to bring their blood pressure back up. We didn't give them atropine to raise their heart rate up. Nothing.
You'd agree with me that there can be very severe symptoms from oral ingestion of tetrahydrozoline.
I would call all of these severe. You know, when they use it for sexual assault in these kids, they're spending a day in the hospital. All of this is like severe.
Sir, did you write an article called Prolonged Cardiovascular Effects After Unintentional Ingestion of Tetrahydrozoline?
Yes,
Was that in the year 2008?
probably. It'll say on the paper.
Attorney Kukler didn't show the jury that article, did she, this morning?
I don't know.
Okay. In that article, would you agree with me that your opinion was that clinical effects from ingestion of tetrahydrozoline have included drowsiness, coma, respiratory depression, bradycardia, hypotension, hypotonia, muscle flaccidity, and hypothermia?
Yes. But they all wake up. I could go through why, but we won't.
You'd agree with me that there is much more literature about tetrahydrozoline published involving people who survived its use.
Yes.
And you'd agree with me that some of the symptoms in that literature include CNS depression,
Yes.
shallow respirations,
Yes.
requiring intubation,
In some cases, yes.
apnea.
Yes, but if you touch them, they breathe.
I'm sorry.
If you touch them, they breathe. If you just, yeah, I'll go through this if you want to know the mechanism. But
Touch them and the apnea is gone.
I believe I'm not allowed to answer questions I'm not asked.
The defense called you as a witness. They'll have an opportunity to ask follow-up questions should they deem it appropriate. It is important just to answer the questions that are being asked.
Yes, Your Honor.
Thank you.
And you're aware that tetrahydrozoline ingestion can cause complete atrioventricular block.
Yes, AV block.
That's a serious thing. Wouldn't you agree with me?
The thing is the ventricles keep pumping. Atria, there's a heart, there's two atrium and two ventricles. The ventricles have their own rate. And so even if you have AV block, the ventricles still pump.
In terms of on a
We've got
spectrum,
reports of complete AV block and they wake up.
Mhm. In terms of putting these things on a spectrum, would you put atrioventricular block as more or less serious than dizziness?
More.
Okay. You testified this morning about what France offers consumers for eye drops. Do you remember that?
Yes.
And you testified that anyone can get Nefazoline in France,
I
right?
believe so, yeah.
Yeah. That doesn't have tetrahydrozoline in it, does it?
No?
You cannot go into a store in France and buy eye drops with tetrahydrozoline in them.
No, it's not approved in France. It's the same mechanism. They're all imidazoline derivatives. We have 3 available in the US. They have 1.
You testified this morning that you can take as much ibuprofen as you want and you're not going to die.
Close. You have to get more than 450 milligrams per kilo.
Mhm.
So if you want to do the math, say you're 100 kilos, that's 210 pounds. 450 times 100, you have to get like, it's just the Costco bottle. So yes, there is ultimately an amount, but it's the least dangerous of the over-the-counter analgesics. Aspirin and acetaminophen are quite dangerous. Ibuprofen isn't.
You'd agree with me that this morning after you told the
Roofers are furious about this new product that's going viral. Replace your whole roof in as little as 8 hours?
Attorney Kukler showed you an article that you wrote that reports fatal overdoses with ibuprofen alone in the number of 15.
I'm going to object to her saying what I did. 'cause
She
it's-
can, overruled,
It's just
it's
not
crossed, she can ask the
accurate.
question.
450 milligrams per kilo. We know the dose. That's a lot. People are, when they want to do it, they do it.
I'd like to bring up Exhibit 544, please. Mr. Spiller, you do not have a MD, true?
True.
You do not have a PhD, true?
True.
You have a master in what?
Toxicology.
Okay. Because on this exhibit, it says that you have a master of science.
Yes, it is a Master of Science.
But this morning and just now when I asked you, you said that your master's degree was in toxicology.
Well, if you can either get a Master of Arts or a Master of Science. That's what the degree says. Then your specialty is whatever. And I put my thesis, which was carbon monoxide in the home, source and epidemiology.
The school where you received that degree, Columbia Pacific University, no longer exists
No, I don't think so.
because the state of California shut it down by court order.
Don't know. It was long after I was involved with it.
And degrees that were issued after 1997 aren't even recognized anymore.
Again, that was a decade after I was involved with it.
On this page of your CV, you also list an American Board of Forensic Examiners, right?
Oh, there, yes,
That's also been shut down, hasn't it?
probably.
And the
That's the
found-
one we were talking about that I no longer belong to.
Mhm.
It's something I did back in the 90s.
That's all I have. Thank you, sir.
Yes.
Redirect.
Get mic'd up. Mr. Spiller, your CV is 44 pages long, right?
Yes.
There's dozens and dozens of articles, more than 100, maybe 200 articles that I didn't show the jury today, right?
It's about 220.
Okay, we did. And it's fair to say during the break, despite Attorney Nikolai's suggestion that I showed you some article about, what was this article about? Because I've never even seen that article. Acetaminophen or something like that?
Tizanidine? No, I don't know.
I didn't show you any article about that during the break, did I? About acetaminophen.
Oh,
I'm saying that I didn't show you this article that she's talking about during the break.
okay. Yeah, I
True.
think we're talking about the difference in acetaminophen, aspirin, and ibuprofen.
Right.
Is that what we're talking about?
That's right. I'm just saying, I didn't show you that. We didn't talk about that during the break.
Objection, this was entered by defense as exhibit 626.
That's not the question. The insinuation was that I.
Hold on, stop. I'm excusing the jury.
Ooh, we're going to have a dressing down here. Oh boy, she is not happy.
Be seated. I'm warning both sides. Stop with the speaking objections. It needs to stop now. And we need to be very precise on when we refer to things that I know have happened in the course of this case. And I'm referring to that sidebar. And I'm going to make a record of that right now. And then we'll bring the jury back out after I address this last objection. As it relates to that sidebar, the defense initially objected to receipt of 232. I sustained it, frankly, just because of a foundation. I thought some more questions could be asked, maybe even show the witness the exhibit. But I also know, because we had a hearing in December of last year, specifically on December 9th, where 232 was marked as Exhibit 8. And this witness at that hearing was questioned about that document. And it is fair game for the state to ask him his knowledge about it and what its source is. And number one, he's an expert. He's provided opinions today in front of this jury in forensic toxicology. These are guidelines for opinions and testimony in forensic toxicology. His knowledge of them or lack thereof goes directly to his credibility, which this jury will need to determine. I've already referenced he was questioned about it at a prior hearing, again, Exhibit 8. Of course, the defense can redirect, that's appropriate. But then Attorney Kukler accused me of yelling at her in front of the jury, which I was not doing. Out of an abundance of caution, I turned my face away from the jury box and directed it at the back of the courtroom. Was I frustrated? Absolutely. I was frustrated because I knew what this witness had been shown and testified about at that prior hearing. And more importantly, the defense knows about it because it's a transcript that is in this file that was requested by the defense. And so I was frustrated because because the defense knows better. And I'm just making this record abundantly clear. I was not yelling. I was in a hushed tone. And I think she said, well, it looks like you're yelling at me. That's why I turned away. And was I frustrated? Absolutely. And I'm also frustrated because of the speaking objections and trying to get information in front of this jury through either making comments or testifying, which, as you both know, that's not how it is properly done. I also know I sustained an objection. I know you moved on, Attorney Nicolai, and I said I'd take it up if you so wish. Is that a topic you wish to go back into?
I can do that with Dr. Kasenko.
All right, very well. Anything the state wants to add to the sidebar?
No.
Anything the defense wants to add to the sidebar?
Just that I wondered if the court wanted me to talk to the witness since he didn't seem to remember it. And I couldn't help that the witness at that moment didn't remember seeing the guidelines. And I recommended that the state hand him the actual exhibit, and maybe that would refresh his recollection. It seems like it did.
I appreciate you adding that. And I will also add at that sidebar, I said, well, it was offered. There didn't seem to be a yes or no, but in any event, I said, that's a good idea. Let's give him the exhibit and we'll go on from there. With that, we'll bring the jury back out. If there are any more objections, just say objection. If you want to say relevance, again, 1 or 2 words. I don't want speaking objections. And I am going to say this outside the presence of the jury, Mr. Spiller. This came up during our motion hearing. I know you have a lot of information and I know you want to get it out, but let the attorneys direct by asking you the questions. Sometimes they call for yes or no answers, and please just do that and not provide extra information. There hasn't been really a whole lot of objections, and sometimes that can be for strategy reasons, but it's important though that you do that and not talk over the other, the attorneys who are asking the questions, okay? You understand that?
Yes.
Good. And you're hearing okay?
As long as the microphone works.
They should be working.
Question when we broke? I'm sorry, could I ask Madam?
Well, there was a speaking objection and I dismissed the jury just to let you know.
But I don't know if you ruled on the objection.
What was the, well, I haven't called for them yet. I did not. Madam Clerk, Madam Reporter, what was the last question that was asked? If you can tell. Do you recall where you were at, Attorney
I
Kukler?
think that I was asking whether or not during this lunch break, I showed
Oh, right.
Mr. Spiller any articles, because I didn't. And I thought it was about ibuprofen or something. I was just trying to get the name of the articles at the district.
What's the
attorney.
number? I believe the state referenced an exhibit.
626.
626.
So my objection was to the inference that this study was never introduced by the defense today. And it was. It's an exhibit.
See, now I didn't ask that, Judge.
Well,
I
hold
just
on.
asked him if we talked about it during the break. Because did you notice that the state said, I want to talk to you about an exhibit that Attorney Kukler showed to you during the break. That's how the question was asked. And I didn't show him any exhibit during the lunch break. So that's the point.
Well, be that as it may, 626 is an exhibit.
I know that.
So it should be accurately portrayed as such by both sides if they reference it as an exhibit previously received in this case. I think you've made your point. You asked the witness if he saw it during a break, if you showed it to him. Madam Reporter, was there an answer given?
That's when the objection came in.
Right, so I'll overrule the objection.
He can answer.
And he can answer the question.
The question when the jury comes in.
Yes, as long as you specifically refer to that exhibit accurately.
All right.
Okay, now we can have the jury brought out. Thank you, everyone. Please be seated. Attorney Kukler, if you would please re-ask the last question that you had asked, but we did not get an answer prior to the court excusing the jury.
Yes, Your Honor. Mr. Spiller, you recall Exhibit 626 that was introduced during this case?
Yes.
And you were asked by the state whether we had met during the lunch hour to review this article. We never met during the lunch hour to review the article, did we?
Correct. No.
You were asked questions about whether or not this data that has been introduced through NMS Labs, if you somehow have access to this data or other people do for the purpose of forming opinions about therapeutic levels, there are some kind of questions about that.
No, it's a proprietary database. You have
What
to
does
be,
that mean?
they own it. So you have to be a member of that laboratory or go through some process and request it. I have not attempted to request it, but proprietary means they own it. It's private. And you can't just go up there and say, let me look at it.
What about when you've worked decades as director of poison control centers? Can people access that data?
Yes.
Why is that?
The CDC and the FDA use this data. They help support MPDS. All other centers use this data. It is a database voluntarily provided by poison centers to have a national real-time picture. Each case goes in within about 10 minutes of occurring, and any updates to that case, any changes to the chart go up every 10 minutes. So it is a real-time database. So often there are medications that they might be prescription and they want to take over the counter. The FDA requires them to get the NPDS data to show them what's been going on with that drug for the last decade or two. The CDC looks at it. We look at for anomalies, referred to. Anomaly is just something that sticks out. It's a machine learning, and it sticks it out. And there's a bunch of us. I do Thursday evening and Sunday morning, and these anomalies, I have to open them, review them, see if there's something up. So if there's a whole bunch of ciguatera food poisoning in Nebraska, we go to Nebraska and say, we need to talk to the public health department. Or if there's just anything shows up, could be a carbon monoxide case, could be this, just anything that shows up. So both the CDC and the FDA use the data because it's been found reliable, and they have access to it in real time. It's about 2:30, so they have in the database up to about 2:10 today is in the database.
So it's within a half an hour.
About 10 minutes, but it could be more if something happens at the center.
Now, you were asked some questions about whether MEs sign death certificates without doing reverse dosing calculations. Do you remember that?
Yes.
But of course, would it be fair to say that there's a lot of death certificates signed that have nothing to do with drugs?
Yeah, I referenced that cocaine case.
And I'm saying people die from all sorts of causes, right?
Oh, absolutely. Heart disease, diabetes, everything. Yes,
So-
cancer. Just natural causes, auto accidents, blunt force trauma. There's just many things.
You were shown and asked about some of the reference notes on the NMS lab report. And I'm going to bring that up again. Exhibit 35. Can we show that on the screen, Madam Clerk?
It's up.
We put it, okay, here we go. And we've seen this report pretty regularly. You were asked specifically about some of these reference notes. Do you remember that?
Yes.
And the state asked you about footnote 5, for example, the alprazolam in the
Yes.
blood. Do you remember that?
Yes.
And you weren't really able to complete your thought on the footnote 5.
Yes.
Do you, what else is there anything else that's significant that, or comment that you wanted to make on
Well,
the
it says,
alprazolam?
other central nervous system depressants such as ethyl alcohol, but that's just such as central nervous system can become toxic at low concentrations. What they're saying that this is additive. This is a synergistic effect. That's why in 2021 we added the black box warning to alprazolam. That was not there for the first 20 years, 20 or 40 because it came out in 81. That was not there for the first 40 years of alprazolam. And so we have recognized that primarily because of the opiate crisis. We started seeing people dying at lower and lower levels of both the opiates and benzos, and recognized that it was a synergistic effect of CNS depressants. Sorry. To the point where the FDA required them to add that black box warning.
What about note 9 on the baclofen? You weren't able to complete your thought about that either. What about baclofen?
Yes, it says toxic blood concentrations are reported in a range of 1.1 to 3.5. 1.1 is what Lynn Hernan had. And again, this is a additive synergistic effect. We have a number of CNS depressants and a number of cardiovascular drugs all hitting this woman at the same time. And she's clearly got baclofen in the toxic range, and baclofen is probably the more dangerous of the ones on there. But because I keep going back to this stool analogy where if you got like 5 legs on your stool and you knock out one, they'll probably stay up. You knock out 2, it's going to be a little wobbly, but you knock out 3 and they fall over. We have this going with the cardiovascular system, and we have this going with the CNS. And we have that here. We have multiple drugs all going after these. Hypotension, CNS depression, respiratory depression. They all are going after that stool and knocking out one leg at a time.
You were showing exhibit 232, and that was the guidelines. I think you might have the copy in front of you still.
Yes.
ANSIASB,
Yes.
best practice guideline.
Yes.
And are you a member of this board?
No.
Why aren't you a member of this board?
It's inappropriate for what I do.
Okay.
The toxicology board I need to be able to run a poison center is the American Board of Applied Toxicology. I have to treat patients, live patients. They're going to call us and they're going to go, we're starting dopamine, what dose? We're going to intubate it, what are we going to do? That does not even, these people are clinical chemists. They're going to tell you the levels that they find on their machines, and they're very good at it. I send some of my samples to NMS. I have sent them there. I have great respect for their reputation, but that doesn't mean these people just getting these levels can interpret them.
Because the people at NMS Labs are all they're getting is a sample of some fluid and asked to conduct a laboratory test on it.
Right. It kind of goes back to the tetrahydrozoline level where the median is 1.7. So 56, half of them are harmless. But they could find it. They're very good. They are excellent chemists.
And does NMS Labs, as far as you know, treat live patients?
No, they don't have the license or the training.
So if this board tells somebody who works in a lab who doesn't treat live patients that they should or shouldn't do certain things, that applies to a person working just in a lab. Is that fair?
Sustained as to the form of the question.
Do these suggestions, and these are suggestions, are they not?
Yes.
And they use words like generally or
Yes.
recommended. Are these would be done by, utilized by somebody in a lab or not in a lab?
In a lab running like GCMS, LCMS, mass spec, that sort of thing, Headspace, a number of them, but they're, I trust their skill in giving me a level, they're great.
But they're not supposed to calculate quantities of pills that would reach a certain level, right?
No.
And the only extrapolation calculation somebody in a lab should do would be, according to these standards, would be for ethanol. Does that sound right? They can do
I
ethanol?
believe, but I haven't read it thoroughly, but that's a real common one that they bring them in for.
And ethanol is alcohol, isn't it?
Yes.
Okay. When you looked into the effects of THC in people, you agreed that with the state that there are some people who report dizziness, right? For example.
Yes.
Now, in these sexual assault cases, is the THC generally from the cases you've reviewed mixed with alcohol or other substances?
In those cases, yes.
So it's not just alone.
Not the ones I've been with, and they usually, you can get people that work at bars that'll tell you this,
You were asked whether or not apnea might be a symptom. I'm sorry you're not feeling well today. I know your ears are plugged up. You were asked if apnea might be a symptom. Do you remember that?
Yes.
Is apnea, I hear of apnea like when people wear one of those breathing machines at night, sleep apnea. Is that what we're talking about?
That is. With these, we actually have these, two of the toxicology fellows were going to create I'm so sorry, a machine that when the respiratory count got down to 10 or less, was going to poke him with a stick. We didn't, because it just seems, I can't see parents saying, oh, put the apnea machine on. It's just like poking him with a stick. But often you just go in, if the mom goes in, picks the child up, if you shake them, that sort of thing, they just kind of, come back up. They are drowsy. You don't completely wake them up. They're not perfect. But it does, there is a case, it only got sent to a meeting, but where a woman was found, they called the coroner, the EMS called the coroner, nobody could find a pulse. Coroner said they're dead. The coroner is a mortician, runs in this particular area, wasn't a medical examiner, but still they take it to the funeral home. They go to dress the body and he starts gasping and he freaks out, obviously. So he calls 911, the same ambulance for the same two EMS people come back. They start CPR. They take her to the ER and she lives, walks out of the hospital after 3 days. But she was found cold. Two healthcare professionals could not find a pulse. You do look.
Next question.
You were asked a question earlier today, and you started to talk about these meetings that you have or you've been part of, these monthly meetings. These are monthly meetings with medical examiners and other people?
No, it's the coroner's monthly meeting for Columbus. It is a medical examiner, Columbus, Ohio, the coroner they made a law, it had to be a pathologist, an MD pathologist. So their coroner is a medical examiner in Columbus. And they would ask us to come, not just us, there were a number of people because they'd ask for the police, jail, mental health people. We would go through the case to see if there was, we could figure out something we were missing because we have these people dying. And so everyone were put in. And once they brought up, we had the case. This person was, he had asthma. He was in the hospital 3 days earlier for asthma, got discharged, comes home. The 911 call is played. He's saying, I'm short of breath, asthma symptom. He's talking normally. He's not wildly agitated, seizing, anything like that. They pick him up. He goes to the hospital and he ultimately dies of his asthma attack in the ER. But they found cocaine on this guy. So they were like, it's cocaine. And we're like, no, I mean, I don't want this guy going, his last thing being, I died of a cocaine overdose when it was really his asthma. So we discussed it and they changed it.
You were asked about Exhibit 623 at length about the different calculations that you made, or at least the calculation you made for one of the children in that study where you calculated at peak, the child would have been 115 ng per ml.
Yes.
And you were asked also about Dr. Kasinko's study again, what you called statistical trickery.
Okay, I did.
Yeah, okay.
I don't mean to be rude, but
All right.
I don't like when you present statistics that look one way and they really are the other. I mean, the median is really the only level there that should be put forward.
I mean, why shouldn't you look at the mean?
Because an outlier pulled that mean way off. The use of like levels of 1, 2, 1, 100. And that a mean would be 27 or 26. The median is going to be 1. And so you look at the difference, and that's why you want someone who's reviewing this knows how, is not just an expert in tetrahedral oscillating, but is also an expert in databases and statistics.
Have you testified in many cases over your career?
I'm 69. It's probably been 30, 35, Sometimes it's 1 or 2 a year, then it's a couple of years I don't.
So just in general, when you talk about polydrug overdoses, how serious do polydrug overdoses get?
Depends on what's in the polydrug, but they get increasingly serious because of the synergy. If we have 2 drugs that are both working on, say, heart rate or blood pressure, and we have 2 more that are working on CNS depression and respiratory depression, and we start to get these additive, they get really serious. So it is, generally speaking, like we've done a lot of studies, and the polydrugs are always the worst. They have greater numbers of major effects, greater numbers of fatalities than single.
And so that's that stool you're talking about. If we've got the 5-legged stool, all of these drugs knocking out the legs of the stool.
Yes, slowly. Yeah. One, because your blood pressure, for example, you've got smooth muscle around the arteries. That'll constrict them. You also have heart rate called cardiac output. If you want to increase the blood pressure, your heart rate can go faster. That's fight or flight response. You also have baroreceptors in the neck and your carotid arteries. You have something called ACE inhibitors that are converting angiotensin 1 to angiotensin 2 in the kidney. I mean, there's multiple mechanisms that are used to support your blood pressure. And so if you knock out, like for instance, ACE inhibitors, angiotensin 1 to angiotensin 2, children that get those, we don't care because they have these other mechanisms. But if you start to start to knock out this leg of the stool, knock out that leg of the stool, it gets more dangerous quickly.
Things like baclofen.
Yes.
Injection.
Sustained, as to the form of the question, please.
For what kind of, what types of drugs, for example, might knock out those legs of the stool that we care about?
Nifedipine works
Hold on. There's been a sustained asked and answered. Move on.
Okay.
I'm sorry.
I sustained the objection.
And so in your career, coroners, I think I understood you to say, ask you to come and help them figure out what's going on in a case.
I'd say it's more occasional than regular.
Oh, if I
They
use-
do, but it's not every day. No.
Not every day, but on occasion, you're asked.
Usually when it's something out of the ordinary, and they're like, what is this? So they call us up and we talk to them. Like we had a brodifacoum, which is rat poison. And he didn't know what brodifacoum was. And I told him, it stops your clotting. He couldn't clot. He bled out in the brain and he died. And he's like, what is this? So sometimes when it's out of their expertise, they'll call us.
Did Dr. B call you in this case to seek an opinion?
No.
Did Dr. Kasinko call you in this case to seek an opinion?
No.
Okay, thank you. That's all I have.
All right, thank you. All right, Mr. Spiller, thank you for being here. You may step down. And thank you. I also am going to excuse the jury before we go forward with any additional witnesses. This will be your mid-afternoon break. It's a little earlier than I wanted, but that's okay. I'll rise for the jury, please.
Rebuttal time. Yay. So we have the rebuttal case, jury instructions, and closing arguments. So should be with the jury tomorrow, I think.
Step down. All right, thank you, everyone. We'll take our break as well. We'll come out and Attorney Kukler, will you have any additional witnesses?
I have got those certified records that I want to introduce.
All right, I will need to do a colloquy with your client, but I need to take a
She's
quick
not going
break.
to testify.
Okay,
All
very
right.
well. I'll come back and do that in 15 minutes.
All right.
Thank you.
Okay, in the past, about an hour ago, I'd say, it looks like we got the verdict back in the Take Care of Maya trial, and the hospital was found liable in the death. So let's see what else we've got. Let's see. Okay, let's watch the verdict over in the Take Care of Maya trial.
The clerk to publish the verdict, please.
In the 12th Judicial Circuit in and for Sarasota County, Florida, case number 2018 CA 005321NC. Jack Kowalski, individually Jack Kowalski as parent and next friend of MK, a minor, and Jack Kowalski as personal representative of the estate of the Beata Kowalski plaintiffs versus Johns Hopkins All Children's Hospital Incorporated defendant. Verdict form. We, the jury, return the following verdict. Claim 1, false imprisonment, October 7th through October 13th, 2016, Maya Kowalski. 1, did Johns Hopkins All Children's Hospital falsely imprison Maya Kowalski without legal authority under circumstances that were unreasonable and unwarranted between October 7th and October 13th, 2016? Yes. 2, what is the total amount of Maya Kowalski damages for medical and psychological expenses to be incurred in the future after she reaches the age of 18 based on the false imprisonment occurring between October 7th and October 13th, 2016? $2,496,000. 3, what is the total amount of Maya Kowalski's damages for pain and suffering, mental anguish, inconvenience, and loss of capacity for the enjoyment of life sustained in the past and to be sustained in the future based on the false imprisonment occurring between October 7th and October 13th, 2016? $3 million. 4, what is the reasonable value or expense of hospitalization and medical, psychological, and nursing care and treatment necessarily or reasonably obtained by Jack Kowalski for his child, Maya Kowalski, in the past, or to be so obtained in the future until Maya Kowalski reaches the age of 18, based on the false imprisonment occurring between October 7th and October 13th, 2016? $67,200. 5, under the circumstances of this case, state whether you find by clear and convincing evidence that punitive damages are warranted for the false imprisonment occurring between October 7th and October 13th, 2016? Yes. Claim 1, false imprisonment, October 18th through October 20th, 2016, Maya Kowalski. 6, did Johns Hopkins All Children's Hospital falsely imprison Maya Kowalski without legal authority under circumstances that were unreasonable and unwarranted between October 18th and October 20th, 2016? Yes. 7, what was the total amount of Maya Kowalski's damages for medical and psychological expenses to be incurred in the future after she reaches the age of 18, based on a false imprisonment occurring between October 18th and October 20th, 2016? $1,400,000. 8, what is the total amount of Maya Kowalski's damages for pain and suffering, mental anguish, inconvenience, and loss of capacity for the enjoyment of life sustained in the past and to be sustained in the future based on the false imprisonment occurring between October 18th and October 20th, 2016? $3 million. 9, what is the reasonable value or expense of hospitalization and medical, psychological, and nursing care and treatment necessarily or reasonably obtained by Jack Kowalski for his child, Maya Kowalski, in the past or to be so obtained in the future until Maya Kowalski reaches the age of 18, based on the false imprisonment occurring between October 18th and October 20th, 2016? $561,298. 10, under the circumstances of this case, state whether you find by clear and convincing evidence that punitive damages are warranted for the false imprisonment occurring between October 18th and October 20th, 2016. Yes. Claim 1, false imprisonment, January 6th, 2017, Maya Kowalski. 11, did Johns Hopkins All Children's Hospital falsely imprison Maya Kowalski without legal authority under circumstances that were unreasonable and unwarranted on January 6th, 2017? Yes. 12, what is the total amount of Maya Kowalski's damages for medical and psychological expenses to be incurred in the future after she reaches the age of 18 based on the false imprisonment occurring on January 6, 2017? $188,000. 13, what is the total amount of Maya Kowalski's damages for pain and suffering, mental anguish, inconvenience, and loss of capacity for the enjoyment of life sustained in the past and to be sustained in the future based on the false imprisonment occurring on January 6, 2017? $15 million. 14, what is the reasonable value or expense of hospitalization and medical, psychological, and nursing care and treatment necessarily or reasonably obtained by Jack Kowalski for his child, Maya Kowalski, in the past or to be so obtained in the future until Maya Kowalski reaches the age of 18 based on the false imprisonment occurring on January 6, 2017? $325,000. 15, under the circumstances of this case, state whether you find by clear and convincing occurring on January 6, 2017. Yes. Claim 2, battery, January 6, 2015, Maya Kowalski. Did Catherine E. and any bedside nurse commit a battery on Maya Kowalski on January 6, 2017? Yes. 17, what is the total amount of Maya Kowalski's damages for psychological treatment incurred in the future after she reaches the age of 18 based on a battery occurring on January 6, 2017? $4 million. 18, what is the total amount of Maya Kowalski's damages for pain and suffering, disability, physical impairment, mental anguish, inconvenience, and loss of capacity for the enjoyment of life sustained in the past and to be sustained in the future based on the battery occurring on January 6, 2017? $8 million. 19, what is the reasonable value or expense of hospitalization and medical, psychological, and nursing care and treatment necessarily or reasonably obtained by Jack Kowalski for his child, Maya Kowalski, in the past or to be so obtained in the future until Maya Kowalski reaches the age of 18 based on the battery occurring on January 6, 2017? $559,000. 20, under the circumstances of this case, state whether you find by clear and convincing evidence that punitive damages are warranted for the battery occurring on January 6, 2017? Yes. Claim 2, battery, hugs, pats, kisses, and placing on lap, Maya Kowalski. 21, did Catherine Beatty commit one or more batteries on Maya Kowalski through hugging, patting, kissing, and placing Maya Kowalski on her lap? Yes. 22, what is the total amount of Maya Kowalski's damages for psychological treatment incurred in the future after she reached 18 based on Catherine Beatty's hugging, patting, kissing, and placing Maya Kowalski on her lap? $8 million. 23, what is the total amount of Maya Kowalski's damages for pain and suffering, disability, physical impairment, mental anguish, inconvenience, and loss of capacity for the enjoyment of life sustained in the past and to be sustained in the future based on Catherine Beatty's hugging, patting, kissing, and placing Maya Kowalski on her lap? $11 million. 24, what is the reasonable value or expense of hospitalization and medical, psychological, and nursing care and treatment necessarily or reasonably obtained by Jack Kowalski for his child, Maya Kowalski, in the past, or to be so obtained in the future until Maya Kowalski reaches the age of 18, based on Catherine Beatty's hugging, patting, kissing, and placing Maya Kowalski on her lap? $1,000. Claim 3, medical negligence, Maya Kowalski. 25, was Dr. Sally Smith an apparent agent of Johns Hopkins All Children's Hospital at the time and place of any treatment she provided to Maya Kowalski? Yes. 26, was Dr. Sally Smith negligent in the medical care of Maya Kowalski? And was that negligence a legal cause of loss, injury, or damage to Maya Kowalski? Yes. 27, excluding and not considering the conduct of Dr. Sally Smith, were one or more healthcare providers negligent in the medical care of Maya Kowalski at Johns Hopkins All Children's Hospital? And was their negligence a legal cause of loss, injury, or damage to Maya Kowalski? Yes. 28, what is the total amount of Maya Kowalski's damages for lost earnings in the past, loss of earning capacity in the future, medical, psychological, and nursing care and treatment expenses to be incurred in the future? $4,700,000. 29, what is the total amount of Maya Kowalski's damages for pain and suffering, disability or physical impairment, mental anguish, inconvenience, aggravation of a disease or physical defect, and loss of capacity for the enjoyment of life sustained in the past and to be sustained in the future? $22 million. Claim 4, fraudulent billing for Mr. Kowalski. 30, did All Children's Hospital fraudulently misrepresent a material matter in its invoices to Jack Kowalski or his insurers? Yes. 31, did Jack Kowalski or his insurance company rely to their detriment on the fraudulent misrepresentation you found in answer to question 30? Yes. 32, what is the total amount of Jack Kowalski's damages for any deductibles or co-pays incurred as a result of Maya Kowalski's sheltering at Johns Hopkins, or increases in the cost of insurance coverage in the past or in the future, including increased premiums, co-pays, and higher deductibles? $3 million. 33, what is the total amount of Jack Kowalski's damages for the difficulty of finding insurance in the future? $2 million. Claim 5, survivor claim for the intentional infliction of emotional distress in the estate of Beata Kowalski. 34, did Johns Hopkins All Children's Hospital, through the acts of its employees, engage in extreme and outrageous conduct, intending that conduct to cause or with reckless disregard of the high probability of causing severe emotional distress to Beata Kowalski prior to her death? Yes. 35, what is the total amount of Beata Kowalski's damages for pain and suffering or mental anguish caused by the extreme emotional distress prior to her death on January 7, 2017? $3 million. Claim 6, wrongful death claim for intentional infliction of emotional distress causing death in the estate of Beata Kowalski. 36, the Johns Hopkins All Children's Hospital, through the acts of its employees, engaged in extreme and outrageous conduct, intending that conduct to cause or with reckless disregard of the high probability of causing severe emotional distress to Beata Kowalski that was sufficient to be a legal cause of Beata Kowalski's death by suicide? Yes. 37, did the conduct that you found in question 36 create in Beata Kowalski an uncontrollable impulse to die by suicide? Yes. 38, was the conduct that you found in question 36 a substantial factor in Beata Kowalski's death by suicide? Yes. Question 39 addresses damages of the estate. What is the total amount of any damages sustained by the estate for loss of net accumulations? $653,676. Question 40 and 41 address damages of surviving spouse Jack Kowalski. 40, what is the amount of any damages sustained by Jack Kowalski for the loss of Beata Kowalski's support and services and funeral expenses resulting from Beata Kowalski's death paid by Jack Kowalski? $18 million. 41, what is the total amount of damages sustained by Jack Kowalski for the loss of his wife's companionship and protection and for his pain and suffering as a result of Beata Kowalski's death? $50 million. Number 42, what is the total amount of damages sustained by Maya Kowalski for the loss of Beata Kowalski support and services? $2 million. 43, what is the total amount of damages sustained by Maya Kowalski for the loss of parental companionship, instruction and guidance, and Maya Kowalski's pain and suffering as a result of Beata Kowalski's injury and death? $18 million. Question 44 and 45 address the survivor damages of Kyle Kowalski. 44, what is the total amount of damages sustained by Kyle Kowalski for the loss of Beata Kowalski support and services? $2 million. 45, what is the total amount of damages sustained by Kyle Kowalski for the loss of parental companionship, instruction, and guidance, and Kyle Kowalski's pain and suffering as a result of Beata Kowalski's injury and death? $18 million. Claim 7, intentional infliction of emotional distress, Maya Kowalski. 46, did Johns Hopkins All Children's Hospital, through the acts of its employees, engage in extreme and outrageous conduct, intending that conduct to cause or with reckless disregard of the high probability of causing severe emotional distress to Maya Kowalski? Yes. 47, what is the total amount of Maya Kowalski's damages for lost earnings in the past, loss of earning capacity in the future, medical expenses incurred in the past, and medical expenses to be incurred in the future? $3 million. 48, what is the total amount of Maya Kowalski's damages for pain and suffering, disability or physical impairment, mental anguish, inconvenience, aggravation of a disease or physical defect, and loss of capacity for the enjoyment of life sustained in the past and to be sustained in the future? $7,500,000. So say we all this 9th day of November 2023, 4%.
Handing back the verdict form, please. Do the attorneys wish to inspect the verdict form? Please. Yes. Please come. Oh, counsel, please come forward if you wish to inspect the verdict form.
Wow, it's kind of shocking just how emotional those young people were. Just in time.
We are back on the record. Appearances are as they were before. Before I have a colloquy with Ms. Kurczewski, Attorney Kukler, you indicated the last thing you'll do is offer the records that were received following my signing of the court order. Those are from the Department of Health Services. And is there's, oh, I see we don't have Attorney Nicolai. I'm so sorry. Attorney Sitzberger.
That's okay. I can do it.
Thank you. Is there a stipulation to those?
Yes, Judge.
And I know there's a stipulation to receive them in terms of before the jury. Is there any type of stipulation as to Ms. Hernan being a recipient of food share during a certain time period?
Yes, I spoke to Miss Attorney Nicolai.
And
She
she's
is
here now.
back in the courtroom now. I indicated I would just say that these indicate that these are the certified records of Miss Hernan receiving Quest Food Share card from 2015 through the date of her death. And then say nothing more. I also did indicate to Attorney Nicolai that should the jury want these records, I don't think all of it would actually be, I think some of it's confidential and probably wouldn't want to go back to the jury.
Well, if there's a stipulation and agreed facts, then I can include that in the jury instructions, which would take away the need for any exhibit going back to the jury room.
Okay, that would be the best way to handle it.
And is there an agreement from the state then as to that?
Yes, Your Honor.
And so it's certified records received
From the Wisconsin Department of Health Services.
showing, verifying, what's the word you want?
Showing that Lynn
Erin Bootcamp isn't just the chair.
Thanks, Michelle.
Showing that Lynn Hernan received food share, a Quest food share card from 2015 through the date of her death.
All right, and that's agreeable to the state?
I know. I'm just looking. Sorry, I'm just looking. Can you, Donna, can you tell me where it says where it originates or where you're getting the 2015 date?
Sure. Right here.
Oh, I see it now. Thank
See
you.
it?
Yes, Judge, we agree to that.
Thank you. And what will the exhibit number be?
630.
Okay. I have very scribbly notes, Madam Clerk, for the ultimate jury instruction. Hopefully we can read them later. All right. Then it is true, other than my colloquy with Ms. Kurczewski, that when we bring the jury back out, the defense intends to rest.
After I introduce.
After that, yes.
Yes.
After that.
Yes, Judge.
All right. So while the jury is still out, then Ms. Kurczewski, I'd like to have a brief discussion with you regarding your right to testify. And you can hear me okay?
Yes.
All right. And let's just make sure the microphone is close enough to her. First of all, ma'am, do you understand that you have a constitutional right to testify?
Yes.
Do you understand that you also have a constitutional right not to testify?
Yes.
Do you understand that the decision whether to testify is for you to make?
Yes.
Has anyone made any threats against you to influence your decision on whether to testify in this trial?
No.
Has anyone made any promises to you to influence your decision on whether to testify in this trial?
No.
Have you discussed with your lawyers the advantages and disadvantages of testifying and not testifying in this case?
Yes, multiple times.
Do you need any additional time to speak with them?
No.
Have you made a decision?
Yes.
What is that decision?
It was very hard for me to decide, but ultimately I will not be testifying.
All right, and Attorney Kukler, have you, and Attorney Galaviz, so I'm so sorry, have you had a sufficient opportunity to thoroughly discuss this case with Ms. Kurczewski and specifically the decision whether to testify in this case?
Yes, Judge.
And are you satisfied that she is making this decision today freely, voluntarily, and intelligently?
Yes, Judge.
All right, thank you. Then the court finds that Ms. Kurczewski is making the decision to not testify in this case freely, voluntarily, and intelligently with a full understanding of the advantages and disadvantages of doing so under the circumstances of this case. The jury will be so instructed then with the appropriate jury instruction. All right, then lastly, I know that the state intends to offer a rebuttal witness. Is that right?
Yes,
And is that Dr. Kacinko?
yes,
Is that the only rebuttal witness?
yes.
And I know the state had filed, sorry, the defense had filed a motion at one point. Is there still an objection to that?
Yes.
On what basis?
Dr. Kacinko has already testified. I don't believe that anything that she's going to say today will be true bona fide rebuttal evidence that she's expected her testimony will be mostly a repeat of what she's already testified to. Of course, this court has broad discretion in setting a scope of rebuttal testimony. So if this court's going to allow it, I'm hopeful that the court will decide on specific points that are agreed upon or that the court feels are new areas to discuss. But I think that everything we talked about with Mr. Spiller was in response to what was already testified to by Dr. Kacinko.
Attorney Nicolai, will you be addressing this?
Yes. We are asking for the opportunity to call Dr. Kacinko for a few very specific points, rebutting new information that this jury just heard today from the defense witness, Henry Spiller. The bulk of my questions will revolve around the calculations that he was allowed to do. The guidelines that he chooses not to follow when offering those opinions. And I certainly don't intend to rehash testimony that she's already given. I understand the purpose of rebuttal, and that's exactly what we'll be doing with her testimony.
All right, given the offer of proof from the state, understanding my authority in 906.11, coupled with the fact that the state bears the burden of proof and that the proffered testimony falls within the scope of rebuttal, specifically as it relates to the calculations and the guidelines, which were made in Exhibit 232, I will allow the state to call Dr. Kacinko for those purposes.
Judge, did you want a full offer of proof and have me list all the topics that I plan to address? Respectfully, I don't think I'm required to do that. I understand the law, and it will be things that were raised by Mr. Spiller today, including her so-called statistical trickery, as well as a discussion of black box warnings that were inaccurate.
I would say those are fair game as well. So, and I trust that if the parties will utilize their objections as they deem appropriate. Again, I'll remind the parties I would prefer a 1 or 2 word, no speaking objections. If I feel I need additional argument, then I will excuse the jury. All right, then with that, let's bring the jury back out. Do you want me to recite the stipulation or do you want to do it, Attorney Kukla?
I can do it.
Great. Did you fall asleep?
I take care of you. You do so well. Not always.
Depends on how late we go. Oh, I know, because she was gonna, in all likelihood, they will not be. Thank you, everyone. Please be seated. Attorney Kukler, does the defense have any additional witnesses to call or evidence to present?
Yes, we do have another piece of evidence to present. We move for admission of Exhibit 630. This is a stipulated admission. These are certified records, Your Honor, showing that Lynn Hernan did receive food share benefits and Quest card from the Wisconsin Department of Health Services from 2015 through the date of her death.
State agrees with that stipulation?
Yes, Your Honor.
All right, Exhibit 630 is received, and then I will so instruct the jury later on with the agreed to facts in the final jury instructions. With that, Attorney Kukler, anything else from the defense?
No, with that, we rest.
Thank you. State have any rebuttal witnesses to call?
We do, Judge. We would like to briefly call Dr. Kacinko back to the stand.
All right, good afternoon, Dr. Kosinko. If you would please make your way to the witness stand. When you get there, please remain standing. Raise your right hand, and my clerk, Teresa, who's on my left, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Have a seat. First thing I will have you do is to state your first and last names for the record and spell each.
Sherry Kosinko, SHERRIKACINKO.
Thank you. Go ahead, Attorney Nikolai.
Thank you, Judge. Dr. Kosinko, you're here at this point for a very specific reason, and you're aware of that, right?
Yes.
Were you able to view the testimony from Mr. Spiller in this case?
Yes.
I have some pretty specific questions on topics that I'd like to clarify with you about that testimony, okay?
Okay.
There was discussion about black box warnings with Mr. Spiller. Do you recall that?
Yes.
Do you believe that that was accurately defined for this jury?
The black box warnings vary by drug, so I think it's important to understand what they are generally, but also with respect to the specific drugs.
For example, do you recall a discussion of the alprazolam black box warning?
Yes.
What is your opinion on the purpose of that warning?
The black box warning on alprazolam is a warning to consider whether or not it is necessary to prescribe opioids and benzodiazepines together. It is not a warning to never do it. It's just saying if you are going to do so, use caution. And then it continues to say that there are situations where it is appropriate to prescribe both hydrocodone and alprazolam, or I'm sorry, an opioid and alprazolam together.
I have a similar question for you regarding the discussion about the baclofen black box warning. Do you recall that?
Yes.
Are you familiar with the warning associated with baclofen?
Yes, I am.
And why is that warning on baclofen medication?
The black box warning for baclofen is specifically referring to the abrupt discontinuation of intrathecal, which is when it's infused into the intrathecal space, or chronic oral dosing. So it is a warning that you should not abruptly discontinue the drug in those two situations, but rather the drug should be tapered off over time if there is a desire to stop using it chronically or intrathecally.
Now, doctor, remind the jury, please, what your PhD is in.
It is in toxicology.
Would you consider yourself a clinical chemist?
I am not a clinical chemist.
If the jury was told that people at NMS labs do great work and produce levels, but shouldn't be interpreting them, would you agree with that as it relates to you?
Not as it relates to my job, no.
Why would you disagree with that?
I do not do laboratory work at all. So I am not doing any work in the laboratory to determine the concentration. We have a staff of, I believe now over 300, I'm going to toot their horn, amazing analytical toxicologists in the laboratory doing the work. My job is to review the data, make sure that the results are accurately reported, and to offer interpretation into the pharmacology and toxicology of the findings as related to the individual cases.
So would it be fair to say that part of your actual job duty with NMS is to interpret those levels?
Yes.
And does that include interpreting them when asked to by medical examiners?
Sustained.
Do you ever interpret the toxicology data for medical examiners?
Yes, I do. In consultation with medical examiners, yes.
I want to ask you some questions about Exhibit 232. If we could please publish that, it's been entered into evidence.
Go ahead.
One moment. Dr. Kasinko, are you familiar with Exhibit 232?
Yes, I am.
Are the guidelines in this document limited to people belonging to a certain board or association?
No.
Could you please explain to the jury what these guidelines are for?
These guidelines are for people who are practicing forensic toxicology. And by practicing forensic toxicology, I primarily mean offering testimony as to analytical toxicology, so that testing that's done in the laboratory, or interpreting the results of analytical testing in court.
Did Mr. Spiller interpret results of analytical testing in this trial?
Yes, he did.
Is that a forensic toxicology opinion?
Yes, it is.
Does this set of guidelines offer best practices for opinions like that?
Yes, it does.
Is there a best practice very specific about reverse calculations from postmortem samples?
Are you, with respect to calculating a dose from postmortem
Right.
concentrations? Yes, there is.
And what is that best practice?
It is considered inappropriate to calculate a dose based on a postmortem concentration.
Is that what Mr. Spiller did in this case?
It appears so, yes.
Were you able to hear his answer when I asked him what formula or equation he used to do that?
Yes, I did.
And did that clarify for you how he came to the numbers that the jury has seen?
It did not.
Are there formulas for those types of calculations?
There are formulas to be used in clinical toxicology when you're dealing with living patients and primarily plasma concentrations.
Do you actually teach those formulas to medical students?
Not to medical students, no.
But you do teach that to a group of students in what area?
I teach a pharmacology course, a clinical pharmacology course to students in a Master's of Forensic Science program. And as part of that program, I do cover the use of those calculations and performing those calculations in a clinical setting.
What is your instruction to those students regarding performing those calculations with postmortem samples?
That they should never use those calculations when dealing with a postmortem sample.
Why?
If you look at the actual calculations, the formulas that are used, there's a lot of variables in those formulas. And a lot of times we just don't have that information, even in clinical samples, clinical cases, you may not have all of the information. And then when you add on all of the things that were discussed previously that can happen to make an individual person different from a population. So differences in their metabolism, a disease state that affects their ability to clear the drug. Some people have delayed gastric emptying, so takes longer for things to empty out of their stomach. There can be genetic issues that change how someone, I don't want to say issues, that's just different people have different genetics with respect to metabolism of drugs. And then there are all the changes that can happen post-mortem. The post-mortem, we're using blood, and these studies that are used to determine all of these variables are always done in plasma. Whole blood and plasma are not the same. Drug concentrations often differ between whole blood and plasma. And then the topic of post-mortem redistribution is also an issue. So because there are a lot of variables that even in clinical cases, we often don't have the information. And then all of these other things that can happen when you're dealing with a post-mortem sample and using blood instead of plasma, the calculations just do not apply anymore when you have a post-mortem blood sample. The calculations that are used for clinical toxicology do not apply to post-mortem toxicology.
Do you recall, are you a member of the American Academy of Forensic Sciences Standards Board?
So the American Academy of Forensic Sciences, I am a member of that organization. The Academy Standards Board is not a membership organization. It is a a board of individuals who have applied to sit on different committees under this board. I act as a liaison for what's called the consensus body under the Academy Standard Board, but I am not on the Academy Standards Board.
Do you have to even be involved with the American Academy of Forensic Sciences to utilize these guidelines?
To the best of my knowledge, you don't even have to be a member of the American Academy of Forensic Sciences to sit on a committee under the Academy Standards Board. It's just an organization that exists underneath the American Academy of Forensic Sciences, but you could be a member of the Society of Forensic Toxicologists and also sit on the Academy Standard Board committees.
Did you hear Mr. Spiller say that it would be inappropriate for him to be on these boards because of the work he does?
I do not recall that specific testimony.
Object to that question, move to strike. It's from the state's testimony.
The objection is overruled and the witness's answer may stand. Next question.
Would someone who is doing the vast majority of their work in clinical toxicology be disallowed from following these guidelines in any way?
No.
Are you aware of any peer-reviewed literature that actually shows just how unreliable dosing calculations from postmortem samples are?
Yes, I am.
And is that an article from 2021?
Yes.
I'd like to show the witness Exhibit 234.
I did provide Madam Clerk with a paper copy for the court and defense.
Thank you.
Dr. Kasenko, do you recognize Exhibit 234?
Yes, I do.
Is that the publication that we've just talked about?
Yes.
Have you read through this publication?
Yes, I have.
Is it peer reviewed?
Yes, it is.
Could you describe the goal of this study?
You have a paper copy, I believe.
Pass it back.
Thank you.
What was being tested in this study?
This study was designed to evaluate the use of those formulas that I talked about. And there are a number of different formulas depending on the dosing strategy that is used and different variables that are available. So they looked at multiple different calculations and determined if the calculations could accurately calculate a dose based on a postmortem concentration.
How did they know whether the calculation was accurate or not?
So in this case, they had investigative information primarily about what dose of the specific drug in this that they were using was amitriptyline. So they have information on what dose the individual took, and they have a postmortem concentration. So they were able to use the formula to calculate a dose and then compare it to the dose that was known to have been taken.
And is Exhibit 234 a discussion of the findings of that study?
Yes.
I'd move Exhibit 234 into evidence, ask for permission to publish.
No objection.
Exhibit 234 is received, permission to publish is granted.
Sorry, we don't have it digitally. Doctor, what's the name of the article?
Just say no to postmortem drug dose calculations.
And what is the conclusion?
I'm just checking to see if they have a specific conclusion or if I need to summarize it. I don't want to. Actually, may I read directly from the?
Sure.
As expected, both the uncertainty and the accuracy of the dose calculation for a consumed drug from its postmortem blood concentration are too large to allow reliable estimation. This work again reinforces that dose calculations from postmortem blood concentrations should not be carried out.
What page of that were you reading from?
It's in the journal, it's page 1869.
Thank you. That would be under the conclusion heading?
Yes.
Okay, thank you.
Doctor, is that conclusion consistent with the guidelines that we talked about?
Yes.
Is it consistent with the way that you teach your students?
Yes.
The last thing that I want to ask you about, doctor, is the abstract that you created in this case. I'm sorry, you didn't create in this case. It's an exhibit in this case from your presentation in France. Do you recall that?
Yes.
This document, which is exhibit 216, has already been entered into evidence. I'll publish it, please, for the jury.
Go ahead.
Doctor, this abstract was described to this jury as statistical trickery multiple times today. Did you hear that?
I did.
Do you take issue with that?
I do, primarily because I don't know what statistical trickery is.
Okay. What was the goal of putting this abstract together?
The goal of this abstract was simply to report the data from a large laboratory that does a lot of testing and has a large database of results. So I reported the normal statistical ideas that are reported in papers. Means, medians and ranges are what are typically reported when you're talking about large data sets.
The opinion of Mr. Spiller was that you should have only used the median. Did you hear that?
I did.
Is that consistent with the way that data is generally shown in writings like this?
No.
Why?
Typically, we report, when I'm publishing any set of data, I report all the different things I just discussed, the mean, the median, and the range, because each of those numbers tells the reader a different type of information. So I'm making sure I'm presenting all of the data, not just selecting one specific statistic to report.
In this case, in this abstract, is anything in it suggesting to the reader that the mean in this case is a known fatal level of tetrahydrozoline?
No.
Is anything in this abstract telling the reader to come to any kind of conclusion by only looking at the mean?
No.
Was this abstract created by you to try to set the fatal level for tetrahydrozoline in the human body?
No.
Is that something that you're working on?
I don't know that there's a study I could do to set the fatal level of tetrahydrozoline in a human body, because I would never get approval to do the study that would give us that information. I am doing the study because it is a drug that we see in not a lot of our cases, but we see it, and often the concentrations are higher than that one clinical study. So it's just a way of expanding the science on tetrahydrozoline, seeing what data I can put out there that might help people in the future with these interpretations.
That's all I have, doctor. Thank you.
All right, thank you. Cross.
So with regard to the guidelines that you that you referenced today, this is not required. This is not, it doesn't, whether you follow this or not is a personal decision.
They are guidelines, so to some degree, yes. However, I do know that many people working in this organization, it is the expectation of their employer that they follow, that if their employer has adopted the standards and guidelines, that people working in that organization also adopt them.
And so at NMS Labs, your organization apparently adopted this, true?
I don't know that there was a formal announcement, but the general understanding is that to the best of our ability, we do follow all of the published standards and guidelines.
I don't know. I thought I just heard you say that organizations may require that people follow these standards.
They may, and like I said, I just said I'm not sure that we have ever had an official announcement at NMS. We discuss them all of the time in our department meetings. We have people who sit on the different groups and boards. So yes, the expectation at NMS Labs is that employees will follow the guidelines and standards.
And you gave opinions when you were here previously about quantities of THC in Ms. Hernan, didn't you?
I did a calculation on the
That's a yes or a
gastric.
no. Did you give an opinion about it?
I don't believe I can answer that yes or no without in what matrix.
Well, didn't you prepare a letter where you gave an opinion and offered it to this jury about how much THC you thought was in Ms. Herman?
No, I did not.
All right. And so you don't know then as you sit here. Is that true?
I do not know the total dose of tetrahydrozoline, no.
As to the black box that you were asked about before, wouldn't you agree that the black box warnings is FDA guidance to providers?
Yes.
And for instance, in the case of baclofen, which you discussed, the prescription is not supposed to, you have to be concerned if you take that with CNS depressants, right?
I would need to review the black box warning again, the entire text. I don't remember everything that's in it.
All right. And then you presented an article today by Peter Maskell, right?
Yes.
Is that something you provided to the state attorneys?
Yes,
And do you know Peter Maskell?
I do.
How do you know him?
He is a toxicologist who regularly attends different conferences. I've met him in passing.
And I did a quick look. Are you familiar with Google Scholar?
Yes,
All
of
right.
course.
And I did a quick look to see how many times this particular paper, just say no to postmortem drug calculations, has been cited, and it appears to be twice. Did you know that?
No.
Okay. So when a piece of literature is recognized and accepted in the community of toxicology, just like medicine, other people cite to articles, right?
If they're doing related research, yes.
And are you familiar with what what's an H index when it comes to somebody who publishes literature? Do you know?
With respect to an individual?
Yeah.
No, I don't know.
Okay. So you don't know how well recognized Peter Maskell is in the H index or Google Scholar? You haven't looked into that at all?
I have no idea what the H index in Google Scholar is.
Then I have nothing else for this witness.
All right, any redirect?
No, thank you.
All right, thank you. You may step down.
Am I excused?
You are, thank you.
Thank you.
Attorney Nicolai, anything else from the state?
No, thank you.
All right, ladies and gentlemen of the jury, I will declare the evidentiary portion of this trial concluded. You are to pass your notebooks to the bailiffs. They will be kept until you deliberate in the jury room. And at this time, after I give you the instruction, I will not only excuse you for the day, but it is my intention to bring you back Monday for closing instructions and closing arguments, and then, of course, the start of your deliberations. And I'm doing that not because simply it's the weekend and tomorrow is Friday, but there are some things that I need to do with the parties to finalize those closing instructions and to address legal issues that relate to all of those. I need to finalize with Madam Clerk the initial set that I will give to the parties, and that's just simply not done yet. And I don't want you to have to come in and sit in what's still a pretty crowded jury deliberation room while we work on that. It could take an hour, it could take all day. And rather than do that and have you here, and given that we are now ending week 3 and we are ahead of schedule, that I'm going to proceed in this way. But it is very important while you are not here and over the weekend that you heed all of the instructions that I know you have, but that you continue to do that and wait until you deliberate, of course, when you are finally given that opportunity to do so. So with that, I'm going to read, since it is the end of the day for you, and I'll have you back Monday morning at 8:30. So please do not begin your deliberations and discussion of the case until all the evidence is presented and I have instructed you on the law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. This order is not limited to face-to-face conversations. It also extends to all forms of electronic communications. Do not use any electronic devices such as a mobile phone or computer, text, or instant messaging or social networking sites to send or receive any information about this case or your experience as a juror. If you come in contact with the parties, lawyers, or witnesses, do not speak with them. For their part, the parties, lawyers, and witnesses will not contact or speak with the jurors. Do not listen to any conversations about this case. Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit the scene, either in person or by any electronic means. Do not read any newspaper reports or listen to any news reports on radio, television, over the internet, or any other electronic application or tool about this trial. Do not consult dictionaries, computers, electronic applications, social media, the internet, or other reference materials for additional information. Do not seek information regarding the public records of any party or witness in this case. Any information you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer, cell phone, or other electronic device, including personal wearable electronics, applications, or tools with communication capabilities to share any information about this case. For example, do not communicate by telephone, blog post, email, text message, instant message, social media post, or in any other way on or off the computer. Do not permit anyone to communicate with you about this matter, either in person, electronically, or by any other means. If anyone does so, despite your telling them not to, you should report that to me. I appreciate that it is tempting when you go home in the evening and over the weekend to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After this trial is completed, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. With that, please rise for the jury. Tom. Thank you. Be seated. Just want to let you know, I just let Tom, one of the jury bailiffs, know, just to let them know they should be prepared on Monday to work as late as they want to work. So I just wanted them to make those arrangements in case they weren't thinking quite about that. Anything else we need to cover today from the state?
No.
From the defense?
No, thank you. Are we going to address the revised jury instruction?
Not tonight. I am going to work with Madam Clerk when we are off the record for the rest of what is left of today, just to err on the side of caution and to make sure you all have a working draft. I'm going to start court tomorrow at 10 a.m. So, and I'll do my very best to give you a heads up or some lead time on that. And for some reason, if it takes us up to that, then you'll get them and we'll just delay the start by a little bit. But that's my goal, so that we'll start at 10 a.m. All right. Thank you, everyone. We are in recess.
Okay, I think she said 10 a.m. So we get to start half hour later. That works for me. So it'll be jury instructions tomorrow for however long that takes. Could be short, could be long. And I have to chuckle because I'm remembering the jury instruction conference with Dorow Brooks and him building his box fort and hiding behind it. That's a classic. So we will have closing arguments and jury deliberations on Monday. So the end is in sight. So, oops. She was talking, but it was muted. That's strange. Get a sleep in just a half hour tomorrow, but a half an hour is a half an hour. So, I will bid you all a good afternoon/evening, and see you tomorrow, unless you want to skip jury instructions conference, in which case we'll see you Monday. So, until then, we'll see you soon. Bye-bye.